Hello, my name is Sharon Roberson, President and CEO of the YWCA Nashville and Middle Tennessee. Welcome to the YWCA's June Stand Against Racism Lunch and Learn. Our topic for today is constitutional liberties and justice in our day. I am excited about this discussion today. As I say at the YW, these are important community conversations that we need to have. And as we say at the YW, we invite everyone to our conversations, and we do not indict people because there are differences of opinion when we go into these very, very critical conversations. Today, we have Professor James Blumstein, and as I will say, I graduated from Vanderbilt Law School in 1983, and he was my professor when I was in law school. So he's been doing this a very long time. He is indeed a constitutional law scholar, and we look forward to hearing and him imparting the same wisdom he did for me long ago today to all of you. We also have Charles Grant, who, for those of you who are not familiar with Charles Grant, he is a premier litigator for this country. He is the person that takes on those difficult cases. And I will say this truthfully, he is the hardest working attorney in the United States of America. So this is very exciting. We also had an unexpected cancellation by Abby Rubenfeld through no fault of her own. She was involved in an accident and she is unable to be here for today. But those of you who know Abby, she is here with us in spirit. She is the reason why Tennessee was included in the same-sex marriage litigation that went before the Supreme Court of the United States. So at some point we will follow up with Abby and she'll be able to give you her wisdom also. We thought it was important to have this lunch and learn because all of us have heard about the leaked opinion from the Supreme Court in the Roe V Wade decision. However, we thought it was very important to go one step higher because what we're really talking about is constitutional rights and liberty. And you have to understand that fundamental concept before you can even get to what the decision might mean for us. So we're taking a deep dive today into the rights of all citizens of the US, which is our freedom to exercise and why individual states are allowed to prohibit certain personal freedoms. Now, the leaked draft came as a part of the decision of a Mississippi case, Dobbs v. Jackson Women's Health Organization. Now, Professor Blumstein is going to give you an overview of how all these cases, including the Roe case, fits together and what this means to us when we look at the rights of individuals. Why is it that the Supreme Court can make a decision that would affect your individual rights? We need to understand this concept. And as I say that there are a lot of people on this call that may agree one way or another on the basic issue of the outcome of Roe, but what we're looking at is what goes into this, what goes into this process. I'm going to ask Professor Blumstein to start off and listen very carefully about how he will lay out the framework that brings us today to the Roe decision or the overturning of Roe. So Professor Blumstein.
Thank you so much, Sharon. It's great to be with you. These are great sessions that you're hosting. Thank you for inviting me to participate, which I appreciate. Charles, thank you for allowing me to share the podium with you. And I want to say a word about Abby Rubenfeld. In her absence, she has been a pillar of civil rights in Tennessee, and she was a great member of this panel, and she will be missed. She's recuperating from a serious auto accident, and our thoughts are with her. I also want to thank Michelle Mowry Johnson of the YW staff and Amber Ellis, the YW staff, who are making this happen behind the scenes. And especially given what a technophobe I am, I especially appreciate their help and involvement. I'm going to cluster around 5 different ideas and develop them in my talk. First, I want, as Sharon said, to give a general overview of constitutional rights and an introduction to what are called unenumerated rights. Where do they come from? How have they developed? What's the history? And then secondly, I want to discuss a case from 1905 called the Lochner case, and gave its name to an entire era where this what's called substantive due process arose and then it fell. And then thirdly, the resurrection of substantive due process in the context of contraception in cases like Griswold, then its development into cases like Roe v. Wade in the abortion area, and then where Abby is a pioneer in the area of same-sex relationships. Then fourth, I will turn to the Dobbs case briefly and kind of place that in this development of substantive due process and see where the court is going to come out, whether that draft opinion that's leaked and circulated is where the court ultimately comes out, or whether there's some other ground that they will rely upon. And then fifth and finally, I will discuss a little bit about where things are, how Dobbs, if the draft opinion holds firm, what is going to change, and what are the open areas where we're likely to see litigation in the future. So that's kind of the once over lightly carpet sweeper treatment of what I plan to talk about. So let me start back on the general area of constitutional rights. Constitutional rights come in many flavors, but we're going to focus upon two. The distinction between specific or protected rights and unenumerated rights. Specifically protected rights are things like speech, religion, the right to petition government for the redress of grievances, all protected by the First Amendment. Those are enumerated specific rights contained in the Constitution. They require interpretation, but they're grounded in the text and the language and the structure of the Constitution. Starting in the late 19th century, culminating in the early 20th century, 1905, in this case that I'm going to mention, Lochner versus New York, the Supreme Court developed what are called unenumerated rights. These rely upon, for purposes of states, on the 14th Amendment, which says that states may not deprive a person of liberty, and the term is liberty, without due process of law. Now, what does that mean, liberty? Well, it means first we have to determine what is liberty, and then secondly, what does due process mean? Due process seems to be a procedure, notice, a right to hearing, right to reasons. These are procedural rights, and no one disputes that the 14th Amendment confers these procedural protections. You can't take away someone's property without giving him or her some ability to defend the claim. In the late 19th century, culminating in the early 20th century in Lochner in 1905, the court added a substantive protection of liberty. That is to say that even if all the procedures are followed, there are restrictions on the government's ability to deprive a person of liberty. The core issue is, what are these liberties that warrant protection? And the substantive protection of liberty means that it's beyond the government to infringe those rights. But what constitutes this core sense of liberty? So that's what I want to turn to now, the Lochner case. In 1905, during the progressive era, many states, including New York, established maximum hour laws for workers. In this case, for bakers. They said you can't work more than a certain number of hours per week. Today, that would be a 40-hour work week. Earlier, it was 60 and then 48, and eventually settled at 40. The court in Lochner said that if the government restricts the ability of someone to work beyond a certain number of hours, that's deprivation of that worker's liberty, that person has the right under what's called freedom of contract to contract to sell his or her labor, and the employer has a freedom of contract to contract for labor, and the government can't put an artificial restriction on the amount of time you can spend working. Now, the government thought it was acting on behalf of workers because it was avoiding exploitation, part of what came to be called the sweatshop. But the workers didn't see it that way, or at least the workers involved in the case didn't see it that way. They saw this as depriving them of the opportunity to work some additional hours and earn some additional income. In today's context, I always ask my law students, what would you think about a 40-hour work week in the practice of law? And of course, most of the lawyers or young lawyers get hives. They break out in hives when you ask them a question like that, because our law students who go practice with big firms, as soon as they leave law school and pass the bar, are having an earning. It's hard for me to even say this, but in the range of $200,000 to $250,000 the minute they start their first job out of law school. It's an enormous sum, but the firms couldn't afford to pay them that on a 40-hour work week. So these are high-priced lawyers, but they spend a lot of time working. And so when you think about is this exploitation or is it opportunity, it a little depends on the context. It depends upon what's involved. But in the bakery context in Lochner, the Supreme Court said that constraining hours to a certain number of hours per week was a violation of their constitutional rights to liberty, and that was the beginning of this era of substantive due process. I want to highlight one other case from that era, from 1925, a case called Pierce against Society of Sisters, another liberty where Oregon tried to force all students to go to public schools. And in Pierce, the court said, no, there's a liberty interest that parents have in raising their kids so that parents can choose to send their kids to private school, their parochial school, the Society of Sisters. And the government cannot force parents to send their kids to public school. That became very important in the desegregation days when states were thinking about forcing students to attend public schools to facilitate a desegregation, and the courts would not permit that. People had to have the ability to go to private school and not to be in a public school environment. By the way, that case still is good law. Now, Lochner was 1905. We get to the New Deal period, the mid-1930s. And from the period of the 1930s to 1963, we saw the demise of Lochner. The courts construed those cases and said that ultimately the court got it wrong. It had no business stepping in to what is essentially a political choice. If the progressive era politicians thought this was exploitation, that should be something that they could choose to do. And they backed away from this whole idea of substantive due process. And basically economic liberty was not given this extra measure of protection that it had been given for over 30 years. As I said, that took about from the mid-30s to 1963, again, another almost 30 years, culminating in a case called Ferguson against Scrupa. So by 1963, a fair reading of these cases was that economic substantive due process was dead, substantive due process was dead. Courts had backed away. They had thought that this was a role for the political branches, not for the courts. Then you get 1965, Griswold against Connecticut, and that is the right of contraception for married couples. So remember, Lochner had been buried in 1963, and by 1965, just 2 years later, the Supreme Court resurrected the concept in Griswold and said, well, we got it wrong in Lochner. Economic liberty is not protected. It's not one of these core fundamental values, but the right to contraception to prevent conception is a fundamental value, at least in the context of marriage. And then eventually that case was extended to unmarried couples and then eventually to same-sex couples as well. So Griswold was an important step along the way. The court was very nervous about doing this, and its description of fundamental interests was actually turned out to be the reasoning turned out to be quite unpersuasive, didn't carry the day, but the court developed this concept of privacy that has withstood scrutiny over time. And so Griswold established that substantive due process exists for fundamental interests, but not for economic liberty, but for personal privacy and personal liberty, like contraception. That was 1965. 1973, Roe v. Wade. Roe v. Wade builds upon Griswold and expands on this concept of privacy. The problem, just as Griswold did not have a firm theory of why that was fundamental, Griswold also, I'm sorry to say, did not have a clear idea of what personal privacy was and why it included the right of women to choose to terminate their pregnancy. Basically, and I went back and looked at this last year, Roe said the right of privacy is broad enough to cover a woman's right to choose to terminate her pregnancy, but it never really explained why. It explained the negative consequences of women not being able to do that, but it never explained why that particular interest was fundamental in the same way that contraception was fundamental. Roe also established the familiar three-trimester system. In the first 3 months of pregnancy, a woman by herself, not even with her husband or mate, but with her doctor, could choose to terminate her pregnancy for any reason that she chose. In the second trimester, the government could regulate in the interest of a woman's health. And in the third trimester, the government could prohibit abortion in order to protect the fetus and the emerging person not yet born. But the problem in all of these cases, going back to Lochner, is to determine what is fundamental, what's the role of the court. And the trimester system seemed to be legislation and triggered tremendous controversy. Then we get 19 years later, 1992, to Planned Parenthood against Casey. And Casey, whereas Roe had really no theory of why abortion was a fundamental interest, Casey did. So Casey developed the principle and established a foundation. Now, one can disagree with Casey or agree with it, but there is a theory. There's not a theory in Roe, but there is a theory in Casey. And the Casey theory linked a woman's right to choose to terminate her pregnancy to her reproductive freedom. And it linked her reproductive freedom to her ability to choose a career, a path, a role in life that only she could choose. And the court linked the ability to control one's procreation to that freedom. So as I say to students, if a woman is a lawyer, up for partner, and she's made all these sacrifices, gone to law school, gone to college, worked her way through a law firm, and now has a great opportunity and becomes pregnant, unplanned, say, the court said basically, look, women have relied upon the right to abortion for 19 years, and you can agree or disagree with this, but the court's theory was that this is a part of kind of after the fact birth control, and a woman has a right to make that determination for herself, whether she is ready to bear a child or whether other values, other things in her life enter in and take priority. And it modified the trimester system with the concept of undue burden. So this is more flexible than the trimester system because states have an interest in protecting the fetus throughout the pregnancy. But basically the undue burden system, again, focuses upon the woman's choice to terminate her pregnancy for her own reasons. Then we come to 1997 in a case involving physician-assisted suicide. The case is Washington versus Glucksberg. And in 1997, the court was facing criticism that it was basically making up what is a fundamental interest? What's the source? Where does this come from? The court had not done a good job in Roe, did a better job in Casey of explaining what is fundamental. And remember, this is the court making a determination of what is fundamental, and in a sense, trumping the political branch. Because when the court says something is fundamental, that means the legislature, the political branches, cannot legislate in that arena. And so the court has been nervous about doing this. But in Glucksberg, the court says, look, we have recognized this notion of substantive due process. We reaffirm it, but we're nervous about it. And so we're going to put some constraints on how courts develop this concept of a fundamental right. And it put two important restraints. One is, we're not going to make up the law going forward. We're going to limit fundamental rights to those that are deeply rooted in the American tradition and in history. So in a sense, the court would discover these rights by looking historically back to the 14th Amendment and not make up a right going forward. You have to have a right that's deeply rooted in our history. And secondly, the court said there has to be not a high level of abstraction, because that gives courts too much freedom to define these rights, but there has to be a careful description or a low level of generality. Because if you go to a high enough level of abstraction, everyone will agree. We'll sit around and sing Kumbaya, and everybody will agree upon this. If you say good is better than evil, you'll get 100% agreement. But what is good and what is evil, you automatically you wind up having disagreements. So Washington attempted to establish that substantive due process was legitimate, courts would do it, but put these two restraints upon how to identify what rights would be specially protected. You have to look through the rear view mirror, not through the front windshield, look to deeply rooted in our history and tradition, and secondly, a low level of generality, okay? That's Glucksberg. The same-sex relationship cases basically eroded the framework. Glucksberg's framework did not survive scrutiny of the same-sex relationship cases. And the court basically eroded in cases like the same-sex sodomy case, Lawrence, the same-sex marriage case, Obergefell. It eroded these constraints that were developed in Glucksberg. And the court, I think, in Obergefell was very forthright. And unlike Roe, which did not give reasons, Obergefell felt obliged to give reasons. It said, look, marriage has been fundamental. It's certainly deeply rooted in our tradition, but we have to recognize that these are opposite sex or heterosexual marriages. And so we're not going to just say marriage is fundamental, and therefore we're going to root this in that history. The court says those have been opposite sex marriages. This is same-sex marriage. And so what the court did is to say, okay, let's try to understand why opposite sex marriages have been deemed fundamental. And the court very carefully and very thoroughly, and again, I'm not saying the court was right or wrong, but very carefully did not dodge the issue the way it did in Roe. It confronted the issue directly and said, here are 4 reasons why marriage is deeply rooted in our tradition and our history. And if you look at opposite sex marriages, they have all those same 4 characteristics, and therefore same-sex marriages should be sustained as fundamental, just the way opposite sex marriages are. And so the court was forthright. It was eroding the doctrine, but it gave a good explanation. Whether you agree or disagree, it was a thoughtful explanation of why same-sex marriages should be treated as fundamental, just as heterosexual marriages had been. Then we come forth to the Dobbs case. Dobbs now is, Alabama has a 15-week cutoff for terminating pregnancy. This does not comport with existing law, which basically goes through viability up to the end of the 2nd trimester. And so a narrow view of Dobbs would be whether to expand the government's authority back into the 2nd trimester to protect the fetus. But there is some thought from this leaked case that the court may go further and overrule Roe v. Wade in its entirety. In the leaked opinion, Justice Alito goes back and talks about Glucksberg, and it looks like he's trying to reestablish the limited framework established in Glucksburg about looking through the front windshield, rear view mirror, not the front windshield, low level of generality, and to establish that in the context of abortion. Abortion, he said, the fetus was not adequately considered the first time around. And so there's some thought that there will be greater fetal protection for fetal life or potential life. And that for the majority, this idea of protecting fetal life is critical. And the court seems to be dialing back, much as the New Deal court did from the 30s to the 60s, dialing back the robustness of the protection of substantive due process. Until the court actually issues its final opinion, we won't know how far back that is or where the court is going to draw the line. But clearly some line is going to be drawn, and it's going to be more permissive of state authority than Roe v. Wade or Planned Parenthood v. Casey. So fifth and finally, where do things stand now? I'll try to wrap this up. I hope that this has not been too much introduction and an overview, but I've tried to make it as concrete so everyone understands the context and the history and how we got to where we are. If Dobbs overrules Roe, as many expect, states will have the power to bar abortion. But they also will have the power to allow abortion. This will be a matter of state choice, and there will be states like Tennessee, I would predict, that would not allow, or at least not allow many abortions. There are other states like California, New York, Illinois, and others, Massachusetts and others, that are likely to be very receptive to the pro-choice position. It'll be a state authority, and then the question of how much authority states have will be frontier questions subject to adjudication. So what are the implications? I've seen concerns about interracial marriage, which was the barrier against interracial marriage in a case called Loving in 1967. I don't think this is threatened. I don't think this is an issue. At this point, it was a race case. Nothing in these cases suggests the court is going to water down consideration of race discrimination. I just don't see that as on the horizon at all. What about states that do ban abortion? What freedom will they have? The details are going to be important. States will have much more freedom to ban abortion. But what about protections for the life and the health of the mother? And thing to look at is if health of the mother is required, then there's a pre-Roe case called the Vweich case that deals with mental health. And so that's one of the things to look at, a battleground. What, even if Roe is overruled, what types of protections for women will be built into constitutional rights even after Roe is overruled, if it is overruled. And so I, again, look to whether there are protections for the life of the mother, the health of the mother. I think almost certainly there will be protections for the life of the mother, whether there will be protections, and if so, how broad, for the health of the mother, and whether that includes mental health. These will be all debated issues. Some states are, there's been talk of prohibiting travel to achieve abortion. I don't think that will succeed. I think that the women's right to choose to go from Tennessee to California for an abortion, if Tennessee tries to stop that, I think Tennessee will, any state that tries to stop that will fail. But there may be ways that states can discourage that, and it depends on the details. And then finally, same-sex relationships. I think these are a legitimate concern. I don't think the same-sex marriage case, Obergefell, I don't think that will be overturned, but I think that some more freedom for states to restrain or restrict same-sex marriages might be in the offing. It depends on what they are, what the rationale is, what the justification is, but I think that is a legitimate concern, and I think there's a battleground. I don't think that same-sex marriage or same-sex sodomy rights are going to be overturned, but what that means about things like adoption of children, raising children, those kinds of questions that haven't yet been firmly decided, I would have concern about those issues. And then finally, what about the effect on transgender rights, which are currently being litigated? I would guess that courts will be more reluctant to develop unenumerated rights for transgender persons, especially in areas in which there are traditional concerns like sports and athletics. I think transgender rights in those areas are going to be hotly contested. I think states and governments will have more freedom to regulate in those areas. But where there's not a good reason to regulate, I think that you will find courts on things like passports, identification on driver's licenses, other types of restraints will be contested issues and lively fought. So Sharon, I've kind of made my way through. I've tried to keep it into my about 20 minutes or so, and I hope that that's intelligible to everybody. And Charles, I welcome your comments or thoughts or criticism.
Okay, I find this fascinating. It's exactly what this audience needs to hear. This has been really, in a nutshell, very concise, but very important information. Let's go to you, Charles. What are your thoughts? We've had the overview. This is the legal framework that the Supreme Court is operating in. We see some things that could happen that will not be positive things from the perspective of those of us who want justice in this country. Charles, give me your thoughts.
Well, the first thing I want to do is to thank Jim for being here, Professor Blumstein for being here. That was an excellent and concise overview. You know, I'm just sorry we don't have more time to delve in a couple of other areas about it. So thank you for being here. And I'm honored to be here to just provide some comments as a non-constitutional scholar, just somebody who just happens to deal with some cases that implicate constitutional rights. The thing that sort of striking in reading the opinion, and I guess it's a matter of opinion or point of view, I suppose, you know, there's a lot of scholarship out there. The opinion goes to great length to talk about the lack of abortion rights at common law. Certainly, it was not as heavily regulated as we understand abortion rights to be today, but there is substantial scholarship out there that says that there were abortion rights and expectations during the pre-quickening period. That Justice Alito discusses in your opinion. Pre-quickening meaning the time before the fetus is felt in the womb, and that there's substantial scholarship as expressed through various amici briefs that right did exist, and that it was legal, that it was considered moral, and it was widespread. And it was not just widespread, that is the pre-quickening of period abortions, not only widespread, but among all of the various communities in the country, both white immigrants, free blacks, enslaved blacks, Native Americans, natives back at the time, all recognized this as moral and practiced it. Did you have an opportunity, Professor, to take a look at some of the amici briefs dealing with the historical underpinnings that, at least as to the argument that these abortion rights did not exist at common law?
Yeah, I mean, these are areas of debate. I'm certainly no expert, and I have not read those friend of the court briefs on that. But the question is not, what was the tradition, whether it was implicit in the concept of ordered liberty as a language or deeply rooted in the Anglo-American tradition. And so the question is not only whether was it permitted, but was it somehow deemed to be a fundamental part of our history and tradition. And I don't have a position on that. I think that I'm gonna have to do more homework and read those cases. But that is a response to this Glucksberg approach, which is to look at history and whether it's deeply rooted. And it's really using that methodology to determine what is deeply rooted based upon history and tradition. That type of historical research, by the way, had a tremendously important impetus in the same-sex sodomy case, the Lawrence case, where the earlier case that had upheld the prohibition had relied upon the illegality of sodomy, same-sex sodomy. And the historian said, but yeah, there was a difference. It was not same-sex sodomy, it was non-procreative sex that was made illegal. And so the court was able, in the Lawrence case, to say, well, gosh, these traditions don't make illegal same-sex sodomy. They made illegal non-procreative sex, whether it's same-sex sex or heterosexual sex. And therefore, it was wrong for the court to read the history in a certain way as preventing same-sex sodomy. It was preventing all non-procreative sex, whether it was same-sex or other sex. So I think history and having a good understanding of history is very important. Whether it's persuasive or not, hard to know. In Brown v. Boyd, you may remember, the court heard it the first time, then it remanded it, and it said, we need to hear from the historians about what the history stated about segregation in schools, racial segregation of schools. And then the court came back the second time and says, well, we've heard from the historians and we think the history is inconclusive and we're not going to rule on the basis of history. And if the history is inconclusive, then basically the plaintiffs are going to lose.
You know, there's been a lot of criticism of this opinion for several reasons. One is because it has overturned what is, it's a constitutional right for nearly 50 years now. And, you know, we talked about Casey and reliance on Roe for 19 years as the abortion right. Have you known of any other decisions by the Supreme Court where the court has recognized a constitutional right and then decided, you know, several terms later, many terms later, but, oh, you know what? We really didn't get that right, even though there were hundreds of opinions after that. We didn't get that right. We're going to overturn that.
Yeah, it's interesting. I mean, it depends. One way of reading the New Deal cases that overturned Lochner is that the right to work, the liberty of freedom of contract that had existed for 30 years was overturned. Now, again, those who had a different political perspective than the court did would say, well, you know, we were just allowing the government to protect people. We're not able to protect themselves. But from the perspective of the plaintiff in those cases, they were denied the freedom to work more than a 40-hour week or a fixed number of hours. So yes, I think the whole demise of Lochner can be construed as the demise of a political right, the right to work, the freedom of contract. And I think the insight was that person A's freedom of contract was basically depriving the government of the ability to level the playing field, equal the bargaining power between employers and employees. So it's not unique. I mean, I think there are, I've read claims that it is unique, but it's not. There are examples of where the court has dialed back these unenumerated rights because the thought was that the courts should not take those claims out of the political process and they should be returned to the political process. If you ask Justice Alito, that's what he's doing in his draft opinion in Dobbs, is that he's returning the issue about how much protection for fetal rights and for women who choose not, you know, who choose not to respect fetal rights, what that proper balance is. Where should that be made? Should that be made in the courts or should that be made in the political sphere? And he would say he's just returning that decision to the political realm. The decision, if it overturns Roe, is not going to bar abortion for any woman. It's going to say states have the right to make that choice and strike the right balance. And in fact, you know, some cynics are saying this, but it looks like from what I've read, 2/3 of the states will probably allow for a pretty robust choice and maybe 1/3 won't, in that range. You know, I think states will not be allowed, in my judgment, I hate to predict like this, but they will not be allowed to prohibit women. Now, they may be creative in thinking about ways to deal with this, but from pure legislation, I don't think a state will be able to legislate that no woman can go from Tennessee, can go, for example, to New York or Illinois to procure an abortion. I think that would violate her right to travel. It would not be sustained. And so at some point, the issue becomes whether organizations like Planned Parenthood are going to find subsidies for women to travel to states that will allow abortion. And of course, for many, that's not going to be a satisfactory answer because it does require some missing of work and traveling, and you may not feel well and you're not around loved ones and so forth. So it's not an ideal alternative, but it is a second best alternative that I think will be available in a post-Roe world for women who choose that. Again, not acceptable to those who strongly believe that a woman should have that right to choose. But even now, under Casey, women can be compelled to give a 2-day waiting period before they choose, even under existing law. And so under existing law, you sit in Nashville for a couple of days and then you have your abortion. Here, you'll know that you have to take those 2 days and travel to New York. So
So
anyway.
to sum up, you do foresee that a number of states are going to ban abortion outright.
Will prohibit abortion like Tennessee will.
Yes.
Yes, I'm guessing. Again, I don't have any special insight on the numbers, but I'm guessing in the range of 15 to 7, about a third of the states will have one type of restriction or another. And I think the important issue there is whether there'll be protection for a woman's life or woman and or her health. And if it's health, whether it include mental health. I think that even if Roe is overturned, I'm guessing that even in many of those 15 or 17 states will allow abortion where the woman's life is at risk if she doesn't have an abortion.
And I will say this, at the point when the decision was made in Roe, abortion was legal in only 4 states and under limited circumstances in 16 states, which gets into the health of the mother, et cetera. So this was a fundamental shift in the availability of abortions for women in the Roe case.
Yeah, and I think viewpoints have changed. That's why I think it won't just be 4 that allow, it'll be probably 30 or 35 that will probably allow one level of generosity or another, and one level of protection or another, even if Roe is overturned. I think that, I haven't done the study. The Guttmacher Institute, which is affiliated with Planned Parenthood, has apparently done its own read on this. And I'm just, again, it's secondary. I haven't read the Guttmacher report, but I've read reports on the Guttmacher report. And the numbers that are suggested there are something like a third of the states, 15 to 17 states, will prohibit in one way or another, and the rest will allow in one way or another. But each one will make a political choice on what levels of protection are appropriate. Will the pro-choice state have a waiting period? I mean, there are a lot of unknowns. Each state will have its own situation. And I'm guessing, I don't want to make light of this, but I'm guessing that there will be some states where abortion will be the easiest. And if you're recommending, if one is recommending to a woman who wants to terminate her pregnancy for whatever reason, who lives in a more restrictive state such as Tennessee, that there will be fundraising, charitable institutions, Planned Parenthood and others will basically raise money for a bus trip if it's close or a plane trip if it's further. And there will be abortion clinics that will spring up close to airports in New York and Illinois and California and other states that will be much more pro-choice, and where women will be able to go meet a shuttle bus and go to the clinic and have the procedure performed and then return. And if they're poor women, that they will have some funding available. But that's no picnic because you're by yourself in a very difficult time. I don't want to make light of that. I think that's going to be an important issue. Now, from the pro-life point of view, I think you will hear the argument to say, well, women will be a lot more careful to use contraceptive, to use pills, and so forth, and to prevent conception, so that they don't have to use abortion as an after-the-fact method of contraception.
I don't remember a lot of my cases from constitutional law, from law school, but I do recall that in 1971, the Supreme Court recognized that the Equal Protection Clause is presumptively violated by state laws that discriminate on the grounds of sex or gender. Those who regard the abortion right as specially protected by the Equal Protection Clause state that state laws prohibiting or significantly curtailing abortion violate the clause because, among other things, they are at least partially rooted in antiquated sex role stereotypes, and because a woman's reproductive autonomy is central to her ability to participate, equally in an economic and social life of the nation. What do you think about, one, the availability of an equal protection analysis for those who want to have this fundamental right continued constitutionally, and two, why did Alito make such short shrift of the equal protection analysis in his opinion? I mean, it was like less than a paragraph. He made very short shrift of it.
It hasn't been the theory under Roe v. Wade, and the sex discrimination claim is very difficult. It's true that sex discrimination claims receive what's called intermediate scrutiny, which does look a little bit like the undue burden analysis. The problem comes that the court has held, for example, limits on coverage of pregnancy under disability programs. The argument was that women are pregnant and that's sex discrimination. The court said, no, it's a discrimination between pregnant and non-pregnant persons. And there are many non-pregnant persons who are women. So that even though only women can become pregnant, there are many women who are not pregnant, and it basically covers all non-pregnant persons. And then finally, the veterans preference case from 1979 held that in order to establish sex discrimination, one has to show that sex is the intent, not just the effect or the consequence. And so one would have to show that that these laws were not really designed to protect the fetus, but were designed to punish women. I think that, Charles, would be a very hard showing to make. I think that people are trying to protect the fetus, not to punish women as women. And it was a particularly hard showing. It's called the Feeney case, 1979. And intent is not just as in tort, where you know what the consequences are, and then you intend the consequence. The court goes out of its way that that's not the intent we mean. The intent is that the government took the action because of the consequence, not in spite of the consequence, even if you know the consequence. And so it's a very hard showing, and that's why I think it's not going to happen, and that's why it was given short shrift on that theory.
Each of the expected, signers on this opinion, Dobbs, if it's actually released by the court formally, it's believed maybe 5, maybe 6, maybe Roberts will sign on, maybe. But each of them testified before the Senate Judiciary Committee that, Roe was settled law. And therefore, we got stare decisis. We're going to We're going to respect precedent. And we, there's been reliance on it, and we're just going to have to move on. We may not agree with how they arrived there, but we're going to move on.
Yeah, and Kavanaugh,
That's
precedent on precedent on precedent. I think that's a question about our political process. As I listened to them, and I haven't gone back and checked the actual language, I think they were careful to leave wiggle room, but they certainly were communicating that they saw this as precedent on precedent, and that stare decisis was particularly important. That's why.
Now, Professor, explain that concept. Explain that concept to non-lawyers on the phone.
Well,
On the Zoom.
Roe and Casey are Roe is the precedent, and then the cases that followed Roe, like Casey, are precedent on precedent. They have cases that build on the precedent, and that makes the precedent even firmer and more well-rooted. I've said this publicly, so I don't think I'm saying anything new that students haven't heard before, that I've been quite critical of the law reform theory of the right to life movement. They, starting with the Reagan administration, is that they have sought to overturn Roe many, many times. That's how you get the precedent on precedent. And it was like the charge of the Light Brigade. They went up and they asked the court to overrule Roe v. Wade. I think a more effective strategy is how Brown developed what I call the termite strategy of law reform, is that you take away a doctrine, you nibble at the doctrine, you nibble at the doctrine, and finally the termites eat away at the doctrine. By the time Brown v. Board was decided, there were so many holes in the doctrine of separate but equal that it was really not really a doctrine. It was easy for the court to huff and puff and blow it down. Not easy politically, but easy from a doctrinal point of view. And that has not happened here. So I thought that there would be, which is apparently the Chief Justice's position, that there would be an erosion. The technical issue in Dobbs is whether government can restrict abortion in the second trimester for prior to viability. And I thought the court would answer that question, yes, that it could. And my strategy, I'm not advising the pro-life groups, but if I were advising the pro-life groups, my strategy would be things like the Tennessee has done. Eliminate race selection or gender selection or disability selection in abortion, what's now called giving reasons, and get a W on the board from your point of view. And then at some point, when you get enough exceptions, then you can go after the doctrine. And in fact, the Tennessee law that allows for reasons has been held invalid, but the Court of Appeals, as I understand it, has put a stay on that. So the reasons rules are still in operation in Tennessee. The Sixth Circuit has held that giving reasons in Ohio was permitted. I think that, to me, would be the next step in law reform, is to say, okay, the states can prohibit basically a Chinese policy where girls were aborted, boys were not aborted, for sex selection and race selection, or child with Down syndrome or some other disability, and to do it kind of step by step through this process of erosion. I don't know what's going to happen eventually, whether that's what I take it Roberts is holding out for, whether he'll get another vote for that. I think that's what I was predicting beforehand would happen in this case. The leaked opinion suggests that they're going to just go right for the end game without going past these erosion principles. And I don't know what's going to happen eventually, but I must say that if you'd asked me this question a year ago, I would have thought that the Mississippi law would be upheld, but Roe would not. It would be eroded, but not overruled. It now looks like the majority is finally taking a final position, reaching the final status, the end game, one or two cases before I thought they would reach it. So.
But therein lies part of the problem, right? This was such an abrupt rejection of Roe and Casey. And at least it's been perceived as an abrupt rejection of Roe and Casey. And we are talking about, what's believed to be a constitutional right, or was a constitutional right, or is it, for 50 years. So, which leads me to my final question is, right now, there are a series of polls on both the left and the right that basically say that the Supreme Court is near an all-time low in terms of public perception of, respect and prestige. Do you have any concerns that this sort of an abrupt about face, especially in light of what these justices said when they went before the Senate Judiciary Committee, that it's a settled law, precedent, whatever. Any concerns about the long-term impact on the prestige of the court as a fair arbiter of the law, as opposed to how some view it as just another, hyper-partisan arm of the government?
Yeah, there's always that concern, Charles. I think I'm old enough to remember the signs that said impeach Earl Warren for his school prayer decisions and his various criminal defense provisions. The court has been under threat before, and so I think you never can be complacent about that. But I think that eventually the court has the ability to shape perception, and it's been under criticism for lots of different things. It's been a criticism on different sides for its racial preference decisions. There'll be a big one coming up next year with the the Harvard case and the UNC case. So I don't disagree with your comment that, sometimes it's called the least dangerous branch. It doesn't have an army. It doesn't have a budget. It has persuasion. And, Jackson, I think this is apocryphal, but it's always, Chief Justice Marshall has made his ruling. Now enforce it. How many brigades does he really have? I don't think that actually happened, but I grew up being told that he did say that.
But he ignored it.
I'm sorry?
This was about the Trail of Tears and the Cherokee tribes, and he ignored the ruling from the United States Supreme Court, and that therein was his remarks. Mr. Marshall's order, now let's see him enforce it.
Yeah, and that's the question, whether he actually said that. I grew up being told he did, but I've now heard others. I'm not, again, expert on that history, but I think that this is always going to be the case, and I think that's why courts are attempt to narrow it, and we don't know what the court eventually in the final analysis will be saying, whether it's going to overtly overrule. At this point, there are other things that confound this, Charles, and that is the court, I think, cannot allow itself to be seen as being bullied by a stolen document. So, I think that changes things dramatically. And I think that we're not starting from square zero at this point. The court may have been mistaken to overrule in the first place, but now that this is out there, the court can afford to allow itself to be perceived as having people threatening and therefore overturning under that kind of pressure. So I don't predict outcomes very, very often, but I would guess that they will go out of their way to say, you can't intimidate us.
Wow, I guess so. And at one point we had thought of lengthening lunch and learn to an hour and a half, and now you all know why. This to me has been so fascinating. Maybe I've just been indoctrinated early on, and so I just love it. This has been a wonderful conversation. I want to also thank Nissan Foundation for making this possible. I believe that this sparks community dialogue, and that is the point of these. Absolutely wonderful. And also PNC Bank, our peace sponsor. I just cannot thank Professor Blumstein and Charles Grant. I know that we're getting so much, people are saying they want you to continue, but I know that we are very strict and we have our time frames, but this has been everything I wanted to be. Hopefully those in our community now better understand, first of all, the framework that's led us where we are today. And also to hope our community remains vigilant. It's not enough to just protest, it's something to shape solutions to whatever cards we are dealt. So thank you, Charles. Thank you, Professor Blumstein. Thank you, those who attended this, and we'll see you the next month for our next Lunch and Learn. So any last words, any last remarks, Charles?
Just thank you to Charles and thank you to you. And just let's remember Abby.
Yes.
Yeah, thank you, Jim, and thank you, Sharon, for inviting me. And I will, reach out to Abby as soon as I'm off this link. That's terrible.
All right. Well, I hope you all had a good time.
All right, take care.
Thank you. Thank you.
Thank
Bye.
you.